And feel free to jump in at any point, because there won't be anybody else probably.
Probably. No worries.
It's awkward for me to just talk to a wall, for an hour, but or more. Okay, welcome to WLJA Radio, Common Law Under God. It is Thursday, March 13th, 2025, and it's a little after 9 p.m. Eastern Time. I think the people in Eastern Time and everybody went back to, or went on daylight savings. Um, okay, the title of tonight's broadcast is Foreseeability, Deferred Gratification, and the Snowball Effect. And I hope that this would have some interest for a lot of people who may spend a lot of time on social media arguing with other people, and who also may be involved in disputes within the legal system. And in any case, it's always good to examine the bases for our beliefs, and in the way we arrive at them, other than just how true is our factual evidence. That's always very big. If you base any belief on facts that are actually false, you're not going to get to any useful conclusions. Garbage in, garbage out. Um, and there, I think, as I put in the comment or the cover to the notice about this broadcast, I see about, what is it, 6 ways to address uh, causation. We're going to talk about causation. I was thinking about it in terms of legal causation, which is a different matter than factual causation. And I wanted to maybe use that as a springboard. There's a very famous causation case that we're going to talk about that it's from I think it's from the early 20th century or late 19th. And it's kind of a classic and gets spoken about a lot of times, and gives you some idea about how illogical the legal system really is. But first, I want to say a quick prayer to our Heavenly Father. Um, we thank you for this opportunity to meet again, and the fact that we're not having technical difficulties tonight, and we are able to communicate to whoever in the world might want to talk about these issues, which hopefully will lead to better communication and the spreading of your word, Lord. So we ask for your continuing blessing, and in Jesus' name, we ask that you be with us tonight. Amen. Um, okay, the part of the notice I had put out was, I think it became a nursery rhyme. For want of a nail, the shoe was lost. For want of a shoe, the horse was lost. For want of a horse, the rider was lost. For want of a rider, the battle was lost. For want of a battle, the kingdom was lost. And all for the want of a horseshoe nail. This this almost sounds like the logical fallacy that I call catastrophizing, because anywhere in this chain of causation, of course, you can break the chain of causation by fixing the deficit. You can get the nail, and so that you don't have to lose the shoe. and then all the other consequences will fail to materialize. But I do find that a lot of people that I talk to on a daily basis do engage in this kind of catastrophized thinking. If I don't do this, and this will happen, and then this, and then this, and then this, and then this, and I'll end up being killed, or my family will leave me, or just any of a number of things that may or may not happen, that probably won't happen, because all along the way, you can intervene in that chain of causation. So as promised, I'm going to get into the classic legal case called the Palsgraf case. That's Palsgraf, famous causation case. And for the overview first, I want to talk about the logic of causes and effects from the perspective of the Bible, from the perspective of the satanic legal system, which we're going to consider first with the Palsgraf case, the satanic medical system, the satanic science system, pure mathematics, and philosophy. And philosophy is where we get into logical syllogisms and fallacies. Okay, so skipping over God's view of cause and effect for a minute, and I'll get into Palsgraf versus Long Island Railroad Company, which is gives you kind of an idea of what the legal system thinks about causation. Because keep in mind, lawyers increasingly make it their business to confuse the language so that it's never clear what causes what, and therefore liability is uncertain. This perpetuates the planned obsolescence, do what you want business plan, or medical plan, big pharma plan, law plan, church plan, just do what you like. If you make sure that there are no choices for the people to go elsewhere, you can be successful. So one of the biggest ways that the legal system confuses the language, and this is talked about with in Mel Stamper's book, Fruit from a Poison Tree. You're not going to get good fruit from a poison tree. And since words are, the essence of every form of communication, and certainly every legal system, he says, I truly believe that many of the problems we have with government and the judiciary today, I question his use of the term judiciary, but to call it that, stem from the deliberate bastardization of the English language by those in government. And we certainly see that today increasingly. People don't have much of a mastery of the English language. So if you're not really clear what it is your conversation partner is saying, because they don't have any kind of a mastery of the English language, that's going to be difficult, or they don't understand your usage of the English language. The laws of English grammar, according to Stamper, are totally inflexible. It is absolutely impossible for any English-speaking nation that prides itself on the assertion that it is a nation of law and not of men, without adhering to a strict discipline in the use of the English language and grammar, to be anything other than a nation of men without law. And then he goes on to say, proper English is essential to the drafting of national laws. Of course, what he's calling laws are merely corporate policy enactments. But, and of course, proper English is not necessarily used in those either. And he points out if you're not using proper English, it's not going to be difficult to end up with tyranny. Okay, so it's got to be clear what exactly you're talking about. And if you're talking about causation, that can mean any of a number of things to an attorney. Here are the basic facts of Palsgraf versus Long Island Railroad Company. 1928 decision from Justice Cardozo. He's considered a very big deal, probably more prestigious than Oliver Wendell Holmes, who many attorneys think was kind of an idiot. In any case, Cardozo gives us the facts. Plaintiff, Mrs. Palsgraf, was standing on a platform of defendant's railroad after buying a ticket to go to Rockaway Beach. A train stopped at the station bound for another place. Two men ran forward to catch it. One of the men reached the platform of the car without mishap, though the train was already moving. The other man, carrying a package, this is a ways from her now. The other man jumped aboard the car, but seemed unsteady as if about to fall. A guard on the car who had held the door open reached forward to help him in, and another guard on the platform pushed him from behind. In this act, the package was dislodged and fell upon the rails. It was a package of small size, about 15 inches long, and was covered by a newspaper. In fact, it contained fireworks, but there was nothing in its appearance to give notice of its contents. The fireworks, when they fell, exploded. The shock of the explosion threw down some scales at the other end of the platform. I guess these are heavy scales, industrial type scales. Many feet away, the scale struck the plaintiff, Mrs. Palsgraf, causing injuries for which she brings suit. Okay, so this would normally have been fairly cut and dried. You have a cause, several people's negligence ends up through a chain of facts, causing the scales to fall and to injure her. The exact nature of the injury may not have been predictable, and that was why this is considered a big foreseeability case, that you shouldn't be responsible even for your own acts of negligence if they don't cause injury that's not only a cause and fact of your negligence or an effect of your negligence, but is a legal cause. It is a foreseeable cause. And so they spent quite a bit of ink talking about who owed a duty to whom, and who was wrong, who did what. Was the guard wrong trying to help the running passenger onto the plane? Was the other guard wrong in trying to push him in? Was there negligence in causing the package to fall by the three people, the one holding the package and the two guards? Was there all kinds of possible negligence, plenty of it to go around? Was the guy who was bringing the fireworks negligent even having them? Of course, today there'd probably be all kinds of statutes and codes saying you can't have possession of fireworks under this, and this circumstance. But the question then that they start analyzing it today to death. Proof of negligence in the air, so to speak, will not do. And this is when they also kind of gave birth to the concept of proximate cause or legal cause, not cause in fact, but cause in law. So negligence is the absence of care according to the circumstances. And it's usually also, it requires a duty to anyone that you injure. If you engage in neglectful actions, it's not surprising if they cause injury to others. You might not be able to foresee the exact nature of that injury, but that's it is foreseeable that some injury could happen. And if you have to weigh between two individuals, and this is Paul's graph, or the three men associated with the rail car that was moving, who should bear the liability? Who should bear the cost? And she's just standing umpteen feet away, and she doesn't foresee that by standing under these scales, that she didn't really do. No one said she did anything wrong by standing under the scales. But the majority opinion, and notice that who's making these decisions anyway? It's Justice Cardozo, and before him, he was the appellate so-called judge. But before him, there was some other black-robed employee making a decision. I'm still scratching my head over why isn't the issue of foreseeability something that should be a jury question. And I think if the jury had that question, they didn't want the jury to have that question. And of course, that's the unexamined premise that the whole thing is based on. Negligence is said to be a mixed issue of fact and law, and it's the black-robed ones that decide what the law is, and they tell the jury what the law is, and the jury applies the facts to the law. That's the theory. But when we do common law, and according to the law of God, we decide, as the sovereigns of this country, we decide when we sit on an adjudicative body, whether we call it a jury or a court, we decide not only the facts, but also the law. And there's plenty of precedent on that, but the bar associations have taken that duty onto themselves. There was a dissent in Paul's graph versus Long Island Railroad that reached the conclusion that, if you're looking at two different individuals, or ones who were who didn't act with due care, and one who was injured, who should bear the brunt of the harm that results? The one who caused the harm in some sense, or the one who suffered the harm? And I don't see where the one who suffers the harm should bear certainly the financial liabilities associated with it. And that's the conclusion that the dissent came to. The dissent seems to be a little bit surprised that there would be that they were in the dissent. And their main proposition is negligent the act is, and wrongful in the sense that it is unsocial. but wrongful and unsocial in relation to other travelers only because the eye of vigilance perceives the risk of damage. If the same act were to be committed on a speedway or race course, it would lose its wrongful quality. This does not mean, of course, the one who launches a destructive force is always relieved of liability if the force, though known to be destructive, pursues an unexpected path. This is part of the majority still. Sorry. They're saying basically, let's say that I'm negligent and cause some event to happen, and then something unrelated causes injury to the plaintiff. Just because I was negligent, if my negligence doesn't actually cause an injury, in fact, then I should not be liable. Even though there's an injury, I don't have to compensate every injured plaintiff. Okay, so jumping to the dissent. Oh, here's one more little soundbite from the majority. We may assume without deciding that negligence, not at large or in the abstract, but in relation to the plaintiff, would entail liability for any and all consequences, however novel or extraordinary. Well, in fact, there's some maxims in law that if you drive your vehicle, let's say, in a negligent manner, and you knock the plaintiff down, and the plaintiff ends up on her head, and she has a skull fracture, it's not a defense to say, well, she had a skull that was as fragile as an eggshell. If it would have been anybody else, they wouldn't have suffered a fractured skull. We should be responsible a little bit, but not to the extent of a skull fracture, because she was unusual. And that's where you get the maxim. You take the plaintiff as you find him. You caused the injury, then you pay for all of it. You know. Okay. The dissent. Assisting a passenger to board a train, the defendant's servant negligently knocked a package from his arms. It fell between the platform and the cars. Of its contents, the servant knew and could know nothing. A violent explosion followed. The concussion broke some scales, standing a considerable distance away. In falling, they injured the plaintiff, who was a potential passenger. An act which unreasonably threatens the safety of others, even when they result in injury to one who would generally be thought to be outside the radius of danger, is still compensable. We might not believe that to the average mind, the dropping of the bundle would seem to involve the probability of harm to the plaintiff standing many feet away, whatever might be the case as to the owner or to one so near as to be likely to be struck by its fall. If, however, we adopt the second hypothesis, we have to inquire only as to the relation between cause and effect. We deal in terms of proximate cause, not of negligence. Well, then they proceed to redefine negligence and proximate cause being different than actual cause. Well, the dissent hangs on to the old definition. If negligence may be defined roughly as an act or omission to act, which unreasonably does or may affect the rights of others, or which unreasonably fails to protect oneself from the dangers resulting from such acts. And here we get the introduction of the word reasonable. If nothing else, the legal system prides itself on being reasonable and adopting rules that are reasonable. But are bar members the ones who should be in charge of what is reasonable and what is not? there's a lot of argument that can be made that the purpose of ordinary people sitting on a jury, or ordinary people who are finders of fact, are the ones who should decide what is reasonable and what is not reasonable. Now, you might get a group of people who, some of whom themselves are not reasonable, and they don't know how to behave reasonably in a certain situation, but there's sort of the community standard, I guess you'd say, I hate to use that term, but of what reasonable looks like. And when you have people acting together, not one black-robed employee acting all by himself, but you have a group of people from the community doing their best to impress each other about how reasonable they are, you're going to probably reach a better conclusion, I believe, than a more just conclusion than leaving it to one bar member. Okay. And then this concept of proximate cause, which can be a whole different thing than legal cause, than factual cause, I mean, it also permeates what they're calling criminal law. In criminal law, both the intent and the result are to be considered. So then you get even more complexity. Did the defendant intend the consequences of his act? Well, under that theory, you can say, well, if Joe Blow rapes Mary Smith, he intends to rape her, but he doesn't know that she has a heart condition, and that the act of raping her might result in her having cardiac arrest and dying. Should he therefore not be responsible if his act of rape results in her death? Should he not? And that resulted in the felony felony murder rule. If you commit a felony and in the process a murder results, or an unlawful death occurs, we'll call it murder. And according to the Paulsgraph majority, no, Joe Blow would not be responsible for Mary's death merely because he raped her, because he didn't know she had a heart condition. So you get kind of an idea of cause and effect in the corporate legal system. Proposition in the legal system is everyone in the world owes the world at large the duty of refraining from those acts that may unreasonably threaten the safety of others. Okay, so to jump back into Bible law, or what the Bible has to say about cause and effect, keeping in mind that our legal system says that it's based on the law of God. Public Law 97-280 acknowledges that when we say we're a nation of laws, when in fact that's false, because it's what they're calling laws are private corporate code policies, corporate policies, not laws, but they're derived from law of God, the original law. And I want to just mention something first. You know, not everybody who listens to this may be a Bible believer or a Christian. And I'm not I'm not taking the position it's possible to prove that God exists. It may be. I don't know. I don't know that. I think there's such a thing as, and certainly the legal system acknowledges it, and some of the sciences and mathematics acknowledges there are certain basic principles that we assume to be true. We operate on that basis, and they're not proven. In mathematics, they're called axioms. One example being 2 points determine a line. All you need are 2 points, and that's you've defined a line. Okay, so to take an example from the Bible of epic bad decision making because apparently this individual was unable to really see ahead the consequences of his own acts. And this was a godly individual by the name of Lot, the nephew, I think, of Abraham. Lot is mentioned by name 29 times in Genesis. Now, Lot is said to be a godly man. But what happened to Lot? What did he do? He certainly did not have it as his goal in life to wake up one morning from a drunken stupor as the father of his daughter's children, but that's what happened. His plan for his life was not to allow everything he owned to go up in smoke in Sodom. Nor did he want his wife to be turned into a pillar of salt and several of his children to be killed. But he made a certain fateful decision when he separated from his relative Abraham. As I understood it, they came to a fork in the road, and I guess it became clear to Abraham anyway that you're my relative, and I'll watch out for you, but I'm going to take one fork and you're going to take the other. You pick first. And if y'all remember, Lot decided to pitch his tent towards Sodom. It looked like a great place to settle. It was on the plains. So he did that, and he began to sow seed, which would be reaped in bitterness. Abraham took the other fork in the road. So what Sodom did after it almost seems to have a certain inevitability to it. Once he chose to pitch his tent at the gate of Sodom. Twice he was targeted as a victim by the men of Sodom. Once when he was protecting his angelic visitors, and 5 times when the angels were protecting him. He seems to be perpetually a victim. He allows himself to be intoxicated by his daughters and then ends up being the father of their children. But if you look at most of Lot's problems, those problems seem to be self-induced. If he had been making better decisions based on the Lord's will, a lot of the bad things that happened to him would not have happened. And of course, how many people make those decisions today that lead to disaster? Do Christians pitch their tents towards Sodom when they make decisions about where to live and work based on how much money can be made in that location? Decisions about entertainment based on what everyone else does and enjoys? Decisions about fashion based on what's socially acceptable? Allowing children to make their own religious decisions without any parental discretion? Okay. And it may seem a small thing as to which fork in the road one takes, but small things add up. David needed only one small stone from a creek bed to topple a giant more than 9.5 feet tall. This is from 1 Samuel 17, 4 through 4, and 1 Samuel 17, verses 40 to 50. If the smallest detail is overlooked or disregarded, unthinkable disaster can occur. For example, Adam and Eve ate the forbidden fruit. In a perfect world was destroyed as they knew it. But it was not just happenstance that Eve ate of the fruit of the forbidden tree. She had to make some decisions that were, even at the time she made them, self-defeating. She made the decision to disobey God. She made she allowed herself to be tempted by the serpent's promise that you too can be as a god. And I think those kinds of motivations are still operating today. Details are important. Anybody who's ever worked as an accountant or computer programmer knows the true magnitude of small details. A pair of digits transposed or a single decimal point out of place can create an accountant's worst nightmare. Yet so often, the adversary tells us, don't sweat the small stuff. That's not God's view. Jesus spoke of God's law in minute detail. For assuredly I say unto you, till heaven and earth pass away, one jot or one tittle will by no means pass from the law till all is fulfilled. Matthew 5:18. The word translated jot in this context is the Greek word iota, the letter corresponding to the Hebrew I, the smallest letter in the Hebrew alphabet. The tittle is the Greek word keraia, which refers to the accent mark used with some letters. If the Lord is concerned with the smallest letters, even the accent marks in his word, who is man to say that details don't really count regarding God's word? I don't know why I put this here, but this is another example of I don't know how many people remember the plight of the Christian baker who was approached by two gay men who wanted him to bake a wedding cake for them. And the baker said, no, I can't do that. That would violate the principles of my religion. I don't approve of what you're doing. I cannot participate in what you're doing by baking the cake. Go somewhere else. However, and this is never talked about in the context of the wedding cake for the two gay men case. Why did this baker set himself up to have this problem to begin with? One reason I would suggest is the baker is operating as a corporation, probably, and he's also operating with a corporate business license, corporate from the corporate state or the corporate city or the corporate county. And so by doing business that way, because some bar member probably told him, you can't be in business unless you have a business license, unless you incorporate to protect yourself against lawsuits. You got to do it this way. You got to do it that way. You can't operate in your own name. Then you'd be relying on God alone to protect you. You can't do that. So here he ends up finally discovering he has religious scruples. But he didn't have to get to that point, is what I'm saying. And of course, the corporate tribunals that have considered this matter never dealt with that. They were dealing with the man's, albeit limited, rights to as a person, because he allowed himself to become a legal fiction person with limited First Amendment rights to practice his religion. And those rights had to succumb to what the corporate state said were his rights under their First Amendment. God gave us unlimited freedom, including the unlimited freedom to make the wrong choices. And when we make the wrong choices, that they're going to lead to consequences that are more complicated for us to address than if we had made the right choices to begin with. And I get this from people constantly. They get themselves into a real mess. And they're in the throes of the corporate legal system, and it's all of its injustices. Oh, it's so unjust. Yes, it is. How'd you get yourself there to begin with? Well, they don't want to talk about that. They don't want to think about that. They don't want to understand the role that their own actions led the role that those actions placed them in, the role that they assumed when they took those actions that disregarded what God would have to say about their decisions. I'm going to address. I got to address this carefully, since YT that allows us to use this platform has some sensitivity against the usages of certain words. I have a white-coated daughter who, in the medical field, who subscribes to the theory that in the context of science and medicine, effects don't have causes in their system. It's all just pure luck or your genetics. You might just get cancer tomorrow for no reason, and there won't be anything you can do about it. It can just strike randomly. Based on that theory, she found a way to justify and wanting to keep a well-paying job, and I don't know what all other benefits. She justified taking money to inject a lot of people with jabs associated with turbo cancers and myocarditis and all kinds of other stuff. Now, she surely did not have the specific intent to cause anybody harm. She just wanted to make a living, make a lot of money for her family, right? What could go wrong? Okay, so I want to get to the next area that talks about causes and effects. I have some knowledge of because I have a degree in math, and I've always been kind of fascinated with the precise logic of mathematical proof. And I'm going to mention again, in math, there's the importance of axioms, fundamental principles that cannot be proven, they just must be assumed. When we have, and there shouldn't be very many of those axioms, and those axioms should be pretty simple. With those axioms, we can draw conclusions that are consistent with what we observe empirically in math, with assurance that we will be right 100% of the time. Unlike with science, where we have to do experiments and we've got confidence intervals and all kinds of qualifications based on probability of error in measurement. With mathematics, you can draw conclusions that will be right 100% of the time, as long as you're basing your conclusions on axioms. I'll just give, I think it's a pretty simple example, but maybe it's not. I know that people have been really dumbed down in the education system. I'm going to use the term integer, which just means a whole number, the counting numbers, 1, 2, 3, 4, 5, 6, and so on. We know what odd integers are and even integers. Even integers are divisible by 2. Odd integers are not divisible by 2. We don't have to assume as an axiom, but we observe that whenever you add 2 odd integers together, you always get an even integer. 3 plus 5 is 8. 7 plus 11 is 18. We don't have to do measurements and measure this empirically. We can use a little simple algebra to prove that this will happen all the time. All the time. Now we can also use simple algebra to prove that the sum of 2 even integers also always equals an even integer. That does not make even integers the same as odd integers. Okay, so outside of the, and there are theories of math that do not derive from axioms that are based on fundamental principles we see in nature, and they arrive at different conclusions. I wanted to just throw this out in connection with what I had said before about mathematical cause and effect, or medical cause and effect, I should say. And I need to jump back to the screen to see if anybody's Well, I'm supposed to accept all cookies, or I'm not going to be allowed to see the screen, I guess, or see the chat box. You still there, Frank?
Yeah, I can see the chat box. There's nothing in the chat box.
Nothing in the chat box. Okay.
Kelby joined us for a little while, but she's not here anymore.
Kelly, did you say?
Kelby,
Kel.
Keelby. I don't know.
Oh, I don't know who that is.
Maybe it's a misspelling. Maybe it's Kelly.
I don't know. Okay, well, jumping back into this, which I got from a probably Alexandra video. She's got a lot of really great videos, generally about what's been called the hidden realm, but also she does a lot of work on the history of religion and the development of certain belief systems. And I think there's people out there who think that Christianity is derived from earlier religions, and that's not exactly what happened. In any case, she talks about science as a religion, as particularly science-ism is what it's gotten to be called, and there's sort of a subgroup of scientists that call themselves materialists, who, as a matter of faith, really decide that, and within what I'm calling science, I would include archaeology. They have made the conscious decision that that unless there is a material scientific explanation for a phenomenon, if they don't observe that, they'll probably just make one up. Because they will never, ever accept a divine explanation for anything, any phenomenon they observe. And here it is in their own words. Here's a Harvard geneticist and a staunch believer in evolution and materialism. His name is Richard C. Lewontin, Lewontin, from Harvard. And materialism is the belief that what is called science can never accept a supernatural explanation for any phenomenon, even if the materialistic scientific explanation makes no sense. Here's the explanation offered by the materialists. This is a direct quote from them. Our willingness to accept scientific claims that are against common sense is the key to understanding of the real struggle between science and the supernatural. We take the side of science in spite of the patent absurdity of some of its constructs, in spite of its failure to fulfill many of its extravagant promises of health and life, in spite of the tolerance of the scientific community for unsubstantiated just so stories, because we have a prior commitment, a commitment to materialism. We scientists have a prior commitment, a commitment to materialism. It is not that the methods and institutions of science somehow compel us to accept a material explanation of the phenomenal world, but on the contrary, We are forced by our a priori adherence to material causes to create an apparatus of investigation and a set of concepts that produce material explanations, no matter how counterintuitive, no matter how mystifying to the uninitiated. Ooh, you have to be initiated to understand this. Moreover, that materialism is absolute, for we cannot allow a divine foot in the door. The eminent Kant scholar Louis Beck used to say that anyone who could believe in God could believe in anything. To appeal to an omnipotent deity is to allow that at any moment the regularities of nature may be ruptured, that miracles may happen. So ask yourself whether science is actually logical or rational at all, or is it a religion, one in which the creator God does not exist but has been replaced by the worship of so-called science, or even of man himself. That last part was my own commentary. Okay, now we're at the 1 hour mark, and we could turn this into another broadcast. I think I could do this in about 15 or 20 minutes. What do you want to do, Frank? Talking about common logical fallacies according to philosophy.
Well, I have a question if there's time, and
Yeah.
I don't know if that influences the outcome.
Okay.
So I don't know if this is a thought exercise or something I heard a while ago, and the message was that, and I guess the question is what's the contrast between man's law and God's law is. I guess we're defining man's law as the one we go to courts for, and the God's law is the one we go to the Bible for.
Mm-hmm.
What is, and so the scenario was presented to be like this. So say you buy a can of beans, and the can of beans is swollen, and you eat it, and you die. Well, on the can it says, if can is swollen, do not eat. Well, okay, part of that is, so if the person is ignorant enough to eat the can of beans even though it's swollen. Another part of it is we don't know where, let's say it's botulinum toxin, if that came into the can during the canning process, when it was under control of the manufacturer, or if the can got damaged and then, bacteria got into the can that way, kind of like the kind of like the case you were talking about at the beginning of
Paul's graph.
podcast.
Yeah. Foreseeability.
Yeah, foreseeability. So so then how would it vary from one perspective to another? This can of beans that has the supposed warning label.
Well, in practical terms, what they would do, well, whether God's law or man's law, is really the only difference, because man's law is based on God's law. Is we would look to more than one agent of causation, because sometimes it takes more than, or we don't know the role that, if A and B together cause injury to C, A and B might be acting together, or they might be acting independently of one another, but they're both at fault in some way, and their fault somehow leads, their combined faults leads to harm for the injured plaintiff C. In the case of the swollen can of beans, of course, that raises some other issues that the corporate system would bring up. Well, the plaintiff, everybody knows that, a swollen can is a sign of the buildup of gases associated with botulism, and should have known not to eat those beans. So that can be said to be there's a number of defenses we can get into. The two prominent ones being contributory negligence, and the other being assumption of the risk. You eat a can of beans that's swollen, you assume the risk. So even if there was negligence initially by somebody else, if you it's said that if you assume the risk and go ahead anyway and engage in eating of the swollen can, you have broken off the chain of causation by assuming the risk. You know, if you jump out in the middle of the street, you know, full of busy traffic, they're not negligent, but you know, even if they were traveling at negligently high rates of speed, you assume the risk if you run out and expose yourself to that. But yeah, so in a practical way, the manufacturer of the can of beans probably should be named, could be named, but if they put a date of expiration on the can, and the can of beans is consumed after the date of expiration, it seems to me that the manufacturer has done everything they could do to avoid the risk to the consumer. And that would be pretty much true, you know, man's law, God's law. And who would be the intervening agent of causation? Whoever sells the can of beans? They really don't have much of anything to do with it, other than well, they could be negligent for not removing that can from their shelves. Is that what you're saying?
I should have focused the question better. The question's more about the warning label. So does that, let's say there's two possible scenarios. There's probably more, but let's say there's only two, where the botulinum toxin enters the can after damage to the can, or it was in the can at the factory. So in the second case, if it was in the can at the factory and you've got a warning label that says, if can is swollen, do not eat, the does the warning label matter? Is the liability still with the can manufacturer?
The warning label was put on by the manufacturer in order to reduce or eliminate his own liability, and I think it would probably be effective in doing that.
Okay.
Yeah.
So it's effective just to say, okay, it wasn't me. It's not me. I'm not the one responsible.
If you warn, if you have a dangerous situation or a potentially dangerous situation, and you have a warning that actually reaches the ultimate consumer of the product, then you've done everything that you can reasonably do.
Right.
Now, there's other situations like you've probably heard of the term attractive nuisance, where you have a swimming pool that's unattended, it's not fenced in or anything, and it could be an attractive nuisance for a child who may not be able to read a sign that warns no lifeguard on duty, or you know, some kind of or no trespassing, anything like that, because the population who might be harmed by that unattended swimming pool uh, may not be able to read that warning. So if you have reason to know that the warning will not reach those who might be harmed, then the warning is ineffective, and it won't protect you. It won't protect the warning giver from liability if it doesn't actually reach the ones that it should reach.
Right. Makes sense.
You know, really, law has always been designed to the law of God to make sense, to be reasonable, and you just see over and over throughout the Bible that people bring about their own misfortunes when they don't use common sense, when they don't pay attention to specific directives from God. The entire book of Jeremiah that I'm still in the middle of is just a wonderful study of how a whole people group ignore God repeatedly and suffer the consequences, and then are given second chances and third chances, and to well, okay, you didn't comply before, but from now on you can. I can't spare you from what you've already brought on yourself, but I can spare you from worse things happening if you do this and this. And I was just reading today where the certain people group, it had already been demonstrated to them that Jeremiah was an accurate predictor of what God said would happen to these people with the Babylonian invasion, and that they were subject to it. And they decided that they were going to. They finally learned their lessons. As they asked Jeremiah, we understand that you've got a pipeline to the Lord, basically, and you predicted it accurately before, and now we're subject to Nebuchadnezzar, and he's only going to do so much to us because he's subject to the will of God. And so ask him again, what should we do now? Should we stay in Judea or should we go to Egypt? And so we'll trust you this time that you're going to deliver the correct word of God. So Jeremiah gets the correct word of God, and he passes it along to the people, and says, he tells you, don't go to Egypt. Stay right here in Judea. No, you're lying. We're going to go to Egypt. Amazing. So they go to Egypt, and and they get slaughtered. Okay. You up for going through the logical errors, or do you
Well, I
want to wait
saw
till next time?
I watched the videos, and
Uh-huh.
I found out that I've been using a lot of those logical fallacies myself to make arguments.
Mhm. Mhm.
And that, well, kind of surprised me. But I sort of picked up the habit at work because I was hearing a lot of people succeeding, making their arguments using these logical fallacies. So they were advancing their point by, for whatever reason, they were advancing their point by using one of these false arguments, and
Oh
I was
yeah.
copying copying what they were doing, not realizing. So it was a good information. I think it's worth the whole
Yeah,
episode.
we can jump right into it. I mean, I think these are common tactics that we either use ourselves or we see used by other people. And the legal system uses these. The legal system is, in fact, based on um, the logical fallacy of appealing to authority. Now, I think that the legal system was on good grounds when they appealed to the authority of the Bible. They were on good grounds there. But what happened is they got full of themselves and they started thinking, well, let's not limit ourselves to what the Bible says is right or wrong. We're going to create our own corporate statutes and codes, and we are going to decide what's right or wrong. And then they use those very same statutes and codes as corporate policies as an appeal to authority. Well, that's an authority. It's an authority because we said so. And that is mentioned in, I don't know, appeal to authority is a very common logical fallacy, and it may not be a fallacy. At some point, you have to appeal to some sort of authority. And better that the authority you appeal to is like an axiom. It's sort of a given. If the authority you appeal to is God, you're probably on good grounds. There's some people who will not allow you that. If you're not going to allow God to be the ultimate authority, then I don't know where that leaves you. Even mathematics depends on some kind of axiom, some kind of a given that we will then extrapolate our conclusions from. But the corporate system adds in a whole bunch more authority that's corporate code than what you really need from the Bible. And they use terminology with idiosyncratic definitions that are not generally accepted by everybody. And
or hard to figure out because
or it's never defined. They'll use a term that you're not exactly sure what do they mean by this term, and it's not defined in the statute. You look in other places in their statutes and codes to see if it's defined, and you never find it. And oftentimes you do, or you find it in several places with conflicting definitions. So which one do you use?
Yeah.
One thing I find interesting with all this talking about Doge and everything, they have never changed their 1792 or 1900 coinage statutes in which they define a United States dollar. That term has been used everywhere, outside the United States, everywhere. It's defined as 24.8 grains of gold or 37.25 grains of silver coinage. So I don't care what they do, as long as they keep using the word United States dollar and we continue to understand what that means, we just use their definition. I'm happy with that. Then we know what we're talking about. Okay, so that would be the first thing. You want to make sure that whatever you're thinking, whatever you're arguing, is based on actual facts or on definitions that everybody understands. They're using the same definitions. You can't use a word that you're defining one way and your conversation partner is defining it some other way. You've got to make sure you're on the same page with your basic definitions of words. So once you do that, and then of course there's the other fact is, if you're using facts that are in fact not factual, you're not going to get anywhere true.
Is it grains per silver or
grains
of
grains?
Grains.
Yeah.
Okay, so 30.
Yeah, not grams. Grains.
So it's what's the definition? 32 grains of silver.
24.8 grains of gold,
Okay.
or
How many?
371.25 grains of silver.
Wow. Okay. Well, that's different. That's a lot.
Hmm.
That's
And that,
according to. I just looked it up. That's worth. Well, in paper dollars, that's worth a bunch.
yeah, yeah.
So
This was an unintended consequence of that enactment, I think. But that's a common thing that they do. They enact a statute or a constitutional provision even, and then they forget about it. It just goes down the memory hole. They don't repeal it, but they pretend it doesn't exist anymore because they enact something else that they think supersedes it because it comes later, but they still got that other one hanging around.
I guess I
So
got it wrong. It depends on how you calculate it. So, so it says it's worth in paper dollars. It's worth $2.65. Is that right?
that would be today in today's
Today.
paper
Right.
FRNs. Yeah.
Okay.
Yeah,
Okay.
and that this is now in 1792 and 1900. That was before there were FRNs, of course.
Right.
Okay, but back to the logical fallacies, which everybody who uses social media will recognize right away. This is the first one I always see, the ad hominem attack.
Yeah. You're not
Yeah,
wearing a suit. What kind of man doesn't wear a suit?
right, right. Or, yeah,
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 they're good. We heard the I don't remember what this one's called. Um, we've we've always done it that way.
yes. Um, Appeal to tradition, I guess.
Okay. Yeah, that's the
Yeah.
one I hear most often in the workplace.
We don't know why. We've just always done it that way.
Right.
Yes.
And it works. And we've done it that way. It always worked. Why would we change it?
Uh-huh.
So,
Right. Right. Um, yeah, that in itself is not going to be sufficient, but that's what we get a lot of today. You know, we've always done it that way. Uh, I got that. I spoke to a minister whose opinion I valued. This goes into another logical fallacy. You go to the expert, and the expert, you know, I've gone to several ministers now because I figured they've been studying the Bible a whole lot longer than I have, and there are things about the Bible that I want to ask questions about, and that their opinions I will weigh heavily. But then I also get into other areas where I can see that they consider that, well, I'm an expert at this and this and this from the Bible. I must also, therefore, be an expert at, well, this man thought he was an expert at, well, you can't operate a society based on the law of God. You can't. He said, then you'd have anarchy. He said, well, not necessarily. And of course, what he's calling anarchy, actually, in during the turn of the 19th through 20th century, there were many societies, small societies, practicing anarchism. They wanted to distinguish what they were doing from anarchy. Um, it was still not the absence of all authority, and of course, um, this minister was against what he called a theocracy, uh, even if it would be, you know, ruled by God, the way God told Samuel in 1 Samuel 7, I think it was, uh, or 8, 7, 8 through 11, I think it is. Uh, that why can't the people just live on their own uh, according to my law, and there would be no need for a legislative body because the Bible is full of all the legislation you need. Why would you need an executive when you have me? This was God speaking to Samuel. You will be my people, and God said this in a number of places in the Bible, not just Samuel. You will be my people. You will live according to my law, and I will be your God. And people who've done that have done well. But there are not many examples of it because people like to do their own thing. They like to be in charge of their own lives. Okay, here's a red herring. Which is an attempt to shift the focus from the debate at hand by introducing an irrelevant point. So we always get that. I can't think of an example off the top of my head, but one is losing a tooth can be scary, but have you heard about the tooth fairy? Straw man argument. You don't like your opponent's argument, so you create a straw argument. You exaggerate or you ignore certain parts of your opponent's argument, and you do a caricature of his argument, and you knock down that argument because you can't knock down the argument he actually made.
Yep, that's one I hear a lot in the workplace too.
Uh-huh. Yeah. So what you're saying is, and then they exaggerate or, misrepresent what you actually did say. Yeah.
Well, I named a project once after the Greek mythology, Daedalus and Icarus, and I named a project. There was a project called Icarus, and there was one that preceded that, or was supposed to be concurrent with it, called Daedalus.
Why don't you tell people what that myth was? I have heard of it, but I can't remember exactly what it was. What was the myth based on?
Trapped in a prison, and they escaped by making wings and to fly out of the prison by gathering bird feathers and making wings with wax and bird feathers.
Okay.
And they flew away, and that Daedalus warned his son not to fly, or warned his son not to fly too close to the sun, else the wax would melt and the wings would come apart. But Daedalus, being youthful and inexperienced, which is sort of the moral of the story, did fly too close to the sun and made that mistake and ended up falling to his death. But as far as the project name, you could call this a straw man attack or you're really changing the argument. It's more of a name change, right? So because the word Daedalus can sound like data loss. And so one of the big managers said, "So you want to call this project data loss?" And so just shot it down with one sentence right there, So kind of funny in hindsight.
Yeah.
But I've seen all kinds of ways that folks do it. I think it would be worth an episode just to take apart some of the arguments that are out there and identify which method they're using, which fallacy they're employing to get their point across.
Okay.
or
Okay.
combination of fallacies, because I think that's the
Mhm.
application of the logical fallacies is what I find interesting. What can we do with it? Once we know they're there, how can we use it to do more critical thinking and critical reading?
A lot of people who are employing these, you know, like the ad hominem attacks, they they don't even understand that they're, what they've done, and
Common in
you can't.
politics. Yeah,
Yeah.
he's he's a he's a staunch conservative. He's a bleeding heart liberal. Whatever, it's meant to engender some kind of emotion.
Right. Right.
That's not even that serious of an ad hominem attack, but he's a Nazi. There's a little more serious one, but
Right. And usually it's not even based on anything factual.
right.
And you could do an ad hominem attack. Well, didn't you get convicted last week of, passing bad checks or something? And you might even have, that still doesn't necessarily mean that what you're saying about something unrelated isn't correct, just because maybe you did pass bad checks the week before. Um, but in a sense, yeah, the legal system uses that one too, uh, unapologetically. So yeah, we can get into that the next time. Um, yeah, yeah, we're an hour and a half in, so yeah. Particularly, this is an important topic because people are tearing each other apart with illegitimate means of arguing that we ought to look into and not participate in ourselves.
Well, when we live in a system that rewards clicks, click on
Ah,
this, click on this, you
yeah.
get paid for that. That
Uh-huh.
makes it a little trickier
Yeah, it
to do
does.
critical reading.
All right. Well, I think I made a note of when our next broadcast would be. I think it's April 10th, but let me check. Yeah, it's April 10th. And so we can continue with logical fallacies. And I was going to also deal with I was going to call the next one Shaming the Shameless. Exposure is not a solution. Because I think we're at a point where we need to do, we need to go further than just exposure. Exposure is based on the assumption that if you expose enough bad things going on, surely somebody out there will do something about it. Um, but that's not necessarily the result. So,
Hmm.
um, okay. Well, thank you very much, Frank, for enabling this broadcast, and we'll continue with logical fallacies and other strategic topics. April 10th, same time, and it'll be the same link. And thanks everybody who may be listening or may in the future be listening. I can be reached as I think you got it on the screen. Um, Frank, I'll just yeah, that's my email address, and my phone is 614 633-0215. Yep. And that's the other email address for the court. Our court website is occr2021.com. Okay. Well, good night, everybody. See you next time.
Good night, Catherine. Catherine, thank you.
Thanks, Frank.